petitioner is subsequent procedure. Vendors, and executed confirmation and ratification. The entire family members. They are now filed a party suit and what has been done, preventing him from illegally ordering. All these factors were brought before the knowledge of the post-settlement court, who has ignored all of these.
Matter. No, I'm asking fresh matter first. Fresh matter kodi. Irade 3 dina sitting. Adralli yav tara ondina hakkodtivi. Fresh matters we have to take. 20? 29th. Tuesday.
Yeah, you know the
Yes, Saturday, yes. Tomorrow, yes. The execution petition dismiss adre ಏನ್ರಿ urgency ಇದೆ. Degree is in your favor. ಇವತ್ತಲ್ಲ ನಾಳೆ execute ಮಾಡ್ಕೋಬಹುದು. Yes, second, yes. Urgency ಏನಿಲ್ಲ. Yes. 28, yes. 28. Yes. We'll have it on 28, yes. Not today. Yes, 28, fresh matter.
For partition, third party will claim the independent title suit is pending. They will implement in the tomorrow.
Not tomorrow. Day after tomorrow, yes.
So for declaration was filed, legal charge was made, though the same has been substantiated without considering the same notice has been ordered, my lord. The respondents are trying to create illegal charge, my lord, on 26th, my lord.
26th, I don't think, because maybe
injunction.
Yes.
An injunction, Lord, has been granted by the trial court against a person who's in possession.
Yes.
With the injunction, Lord, they're trying to take possession of the property. Therefore, my Lord, there's some
How can they take a position on basis of-
forcibly coming into the property and taking with 100 people came the other day.
Yes, tomorrow, yes.
Can I request for 2:30? My Lord?
Tomorrow, yes.
ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಾ ಮತ್ತೆ ಯಾಕೆ ನಿಂತಿದ್ದೀರಿ ಸರ್?
Day after tomorrow, yes. Fresh matter. 2nd June ಅಲ್ಲ ಆಗಲ್ಲ ತಾಳಿ ಆಯ್ತು. 2nd June. Yes, after vacation, yes.
My lord.
2nd June ತಾಳಿ ಅದು.
ಅಲ್ಲ one submission.
Yes, 29th, yes.
ಅಲ್ಲ previous council ಮೇಲೆ previous.
What is that? Are you filing a review petition? No application, disposed of matter, nothing doing. Yes. Tomorrow, yes. Yes, second. Not tomorrow, madam. Yes, 28, yes. Yes. Day after tomorrow, yes.
Page number 1, page wise adjournment, list number 1, page number 1, serial number 1 to 6, page number 2, serial number 7 to 13.
Yes. Yes,
There's some settlement talks that are going on, in fact, we have met yesterday.
yes, you want time
After vacation.
after vacation. Yes, at the request of counsel for the respondent, at the request of counsel for the respondent, leaves this matter on 9th June. Yes.
Page number 7, serial number 33 to 35.
Hmm. Hmm.
Vacating stay.
No, sir. Hmm. Yes, at the request of counsel for the petitioner, leaves this matter on 4th June. Yes, interim order granted earlier is extended till next date of it.
Page number 8, serial number 36 to 41. Page number 9, serial number 42 to 44.
Hmm. 43. Yes. At the request of, have you informed the other side? The request of counsel for the petitioner, leaves this matter after vacation. Interim order granted earlier is extended till next date of it.
Page number 10, serial number 45 to 49. Page number 11.
49. Hmm. You are appearing for petitioner. Yes, at the request of counsel for the petitioner, leaves this matter after vacation.
Page number 50 to 53.
52. Hmm. You are appearing for whom? No, what about that petitioner, madam? Have you informed them? No, you informed and mentioned, yes.
Page number 12, serial number 54 to 60. Page number 13, serial number 61 to 67. Page number 14, serial number 68 to 75. Page number 15, serial number 76 to 78. Page number 16, serial number 79 to KV.
Hmm.
Huh?
Hmm.
ಏನು problem?
Hmm. 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 No, what is that order you are challenging? Transfer petition order has been passed. Why you let them pass an order? They can reject it. No, that is what you have court saying that this application cannot be allowed because of this reason. See, section 24 says it should be between the same parties. They may reject it. Why do you before that? No, you can't say like that, mister. Can you say what I am going to do now? Then how can you say, mister, before passing an order? No, this is the only. ಆಯ್ತಪ್ಪ ಅವ್ರು ಜಡ್ಜಿ ಇರೋದೇನಕ್ಕೆ ಅದ್ರ ನೋಡ್ಬಿಟ್ಟು ಅವರು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋದು. ನೀವೇನ್ ಹೇಳ್ತಿದ್ದೀರಾ ಅವ್ರ ಹಂಗಾರೆ? Then I'll suit come before me and I have to decide. Application is pending. He has not passed an order. Yes, third. This petition is filed by respondent. This petitioner has called in question. Petitioner is seeking set asiding that miscellaneous 143 of 2023 filed by the respondent before Principal District and Session Judge Mysore under section 24 of CPC. The respondent herein has filed an application transfer of OS number 923 of 2021 pending on the file of second additional. At this stage, At this stage, the writ petition is not maintainable. Accordingly, writ petition is dismissed. Why after vacation? You go and press for your application. Let that application is be decided. Tomorrow they may dismiss this application. Why you are before this court? Yes.
Serial number 2, Dayalu KN.
Yes. You are the defendant. Yes. Yes. Now, what is that injunction order granted? Where is that? Where?
Yes, sir.
Now, where is that order? Page number? Page number 34. Yes.
Brigu
Yes,
Yadav.
he is appearing.
Yes, sir, he's appearing.
Yes, Mr.
Am I audible, Manoj?
Yes, Mr. Manoj.
Yes, Manoj. Because the challenge here in this petition is to the order granting amendment to the plaintiff plus respondent. He has filed a suit. The order is at page 20. The relevant portion of the order is at page 29.
No, that you are the defendant.
No, sir.
I am the defendant.
A suit for?
Suit is for recovery of money, Manoj, on the ground that he has supplied certain materials from Bangalore to Chandigarh as to Ludhiana in Punjab, Manoj.
Yes.
During his cross-examination, he had made certain admissions in the cross-examination in my favor, which he now wants to withdraw and make a legal out of those admissions, and therefore he has filed this amendment application.
Yes, you read from para 11, finding reasoning of the bill.
Yes. Advocate for plaintiff argued that due to oversight, these bills were not produced at the time of filing the suit, and there was mistake in calculation of the bills and amount. Hence, if the proposed amendment is allowed, no loss or harm will be caused to the other side. The proposed amendment will change the nature of suit nor cause of action. Hence, pray to allow the IAs. Advocate for defendants argued that these IAs are filed at belated stage. PW1 filed his affidavit in lieu of examination in chief based on the pleadings, and now the plaintiff parties convinced the court regarding necessity of amendment. Court can allow the amendment at any stage of the proceedings, though the plaintiff has filed his IAs after evidence. But looking to the facts and circumstances of the case for proper adjudication of the matter, the proposed amendment is necessary. If proposed amendment is allowed, it will not change the nature of suit nor cause of action. Defendants will have every right to defend the case. To avoid multiplicity of proceedings, the proposed amendment is necessary. The documents sought to be produced under so and so IA are necessary to adjudicate the case of the plaintiff after the amendment.
Yes, except that after that issue is framed, but it will not change the
Please.
cause of action or the
No,
relief sought in the.
Sir, what has happened is the witness comes up in the witness box. In the witness box, he admits that all the documents on the basis of which he has filed the suit is the invoices, then the ledger statement of the account statement maintained by him, that is incorrect. Already admissions have been made in the cross examination, which he wants to withdraw now. If I will take your lordship to those admissions which have
So page number 12.
part and parcel of the cross
Page number 12.
examination, those admissions which have
So page number 12.
part and parcel of the cross
Page number 12.
examination.
Where is that amendment petition? What is that he wants to amend that? Where is that amended?
All right, the application itself, I'll take the code to the application. That application is,
Admitted?
yes, that your lordship may kindly see the admissions at page 81. Page 81.
Yes.
So last 3 lines from the bottom,
Yes.
the total sale amount against the defendant was rupees 1,45 lakhs, whereas in the suit he has filed something else, alleged something as alleged in the legal notice. In the legal notice, he has made some different averments. It is true to suggest that I will mention the amount which was received from defendant number 1 as rupees 53 lakhs 35,006 so and so. I have not mentioned it.
When is the next date?
11th June, sir.
11th June. Yes. Heard issue notice. In addition, petitioner is also permitted to serve a copy on the counsel appearing for the respondent before the trial court. Leaves this matter on 5th June. Yes.
So may I pray for proceedings?
You serve
Stay
a copy.
further proceedings.
No, we will have it on
I
5th. Yes.
Serial
5th
number
June.
40.
Yes.
MP Chandrachuda for petitioner, Kumar Patil.
Yes. Your defendant. Yes. Yes. 310. Yes. Forty-one. Yes.
In view of the discussion made above, Supra, the court is of the opinion at this stage plaintiff has failed to make out a prima facie case. Injunction has been refused.
Yes.
And an appeal was preferred before the appellate court.
Hmm.
Without hearing me, an order came to be passed. The last may kindly take order passed on earlier occasion, Annex J, page 58.
28.
58, 58. I came before this court
Yes.
questioning the order. Your Lordship has satisfied the order and remanded the matter Annexure K, page 80.
80.
80.
Yes.
Holding that I was not heard, I should be given an opportunity. Time has been fixed. Kindly
Yes.
take the time limit fixed by the trial, this court,
Yes.
to the trial court to dispose of the application on merits after hearing the parties.
Yes.
Paragraph number 83 ನಲ್ಲಿ fourth direction.
Yes.
The trial court annoyed about the direction issued by this court, as if you are going to the High Court, fixing the hearing date and pressuring this court. Kindly see the order passed by the appellate court, where it decided the suit itself. Page 101, paragraph number 20. ಕೂಟ ಇನ್ನೇನು ಇಲ್ವೇ ಇಲ್ಲ, ಡಿಗ್ರಿನೇ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ. 101, paragraph number 20. The recitals of the copy of the sale deed dated 3/10/1955 reveal that the mother of the plaintiff Basamma purchased the property measuring 20 to 12 gajas in survey number 101/3 from Siddharamegowda. For the reason best known to her, Khata was not mutated.
Yes.
in her name based on the sale deed, no document is forthcoming to show the same. However, the copies of the tax assessment register extract document issued under the Swamitha plan, endorsement of the PDO, Maskal Gram Panchayat reveal that as on the date of the suit, Kata of the suit scheduled property was standing in the name of the plaintiff. Suit ಹಾಕಿರೋದು 24ರಲ್ಲಿ. Sale of survey number 1/3 so and so. ಈ 1/3 survey number ಇಲ್ಲಿ ಗಜಾಸ್ ಅಂತ ಹೇಳ್ತಾರೆ ಮೇಲೆ, ಇಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಹೇಳ್ತಾರೆ. Kindly go to the next page. Paragraph number 21. As could be seen from the endorsement issued by the PDO Maskal Gram Panchayat, the suit property is situated in survey number 1/3 agriculture land. And it is stated in the endorsement that the plaintiff has been in possession of the suit property long time by constructing house therein, and Kata has been standing in his name since the day when the Gram Panchayat came into existence. The plaintiff has been in possession of the same and his house was dilapidated condition. A house was sanctioned to him under the scheme of Vasati on 21-22. But the objection was raised regarding the ownership of the property on 21-22. But the objection was raised regarding the ownership of the property. An endorsement was given to approach the civil court. The prima facie go to show the plaintiff is in possession of the property. ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಒಂದು ಪ್ರೈಮಾ ಫೇಸಿ ಗೋಸ್. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಡಿ, ನನ್ನ ಕಂಟೆನ್ಷನ್ ಏನು ಅಂತ. Para 22. As noted above, the defendant have specifically contended. First defendant is the absolute owner in possession of the enjoyment of the land bearing survey number 1/3, same land, measuring 8 guntas, having acquired the same under the compromise decree passed in FDP 2 of 1989. Based on the same, revenue entries have been mutated in name as per MR number so and so. Out of 8 guntas, defendant sold 1 gunta in favor of Sarojamma wife Doddai under the research early date. Now they are in possession of 7 guntas of land. Then the copies of the compromise decree MR so and so corroborate the said assertion of the defendant. The recitals of the sale deed dated 6/10/55.
To grant stay here and pending.
I understand, my lords. My only submission is, my lords,
Yes.
it is the case of defendant that he purchased on 6/10/20
No, that's-
1955,
we are not
7
deciding- No, that is true.
Yes,
We are not deciding all these things.
True, my lords.
See, now.
It is my
anyhow
dwelling
that-
house, my lords. I was residing there. It was in dilapidated condition. Now I want to reconstruct. If status quo is ordered, I'll be homeless. Because they're all parties are related. And state court observes that it is only 1/3 share of survey number 1/3 was purchased by the father of defendant. That means a 2.4.
No, to identification,
guntas.
you are constructing in that 1/3 portion or not.
Because my mother has purchased 20 into 12 gajas, that is 60 into 36 feet, if it is measured in terms of feet. That is an admitted fact that in the year of 1955,
His
my
grievance
father.
is that you are constructing in his property.
No,
That is
even
what should be
otherwise,
decided.
even
You
otherwise,
see
my
the
lords,
document which was placed before the trial court officer ಕೊಡ್ತು.
even otherwise, my lords, their right is only insofar as 2.75 guntas is what
I am
purchased.
asking that
ಅವ್ರಿಗೆ
2.75 guntas has to be identified, which is that property. He is saying that.
our document alle kindly take the document I have placed, page number 10.
Yes.
Page number 10 ಅಲ್ಲಿ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ PDF ನಂಬರ್ 112, ಪಂಚಾಯತ್ ಐಡಿ so and so, ನಿವೇಶನ 138/01, ಕಟ್ಟಡ 79/8, ಗ್ರಾಮ ಠಾಣದಿಂದ ಹೊರಗೆ ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಇವರು ಗ್ರಾಮ ಠಾಣದಲ್ಲಿ ಕಟ್ತಾ ಇದ್ದಾರೆ ಮನೆನ. ಅಂದ್ರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಓವರ್ಲ್ಯಾಪ್ ಆಗುತ್ತೆ. ಇವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಇದು, ಇವ್ರದೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಬಿಫೋರ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಆಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ನೋಡಿ, ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಸೇಲ್ ಡೀಡ್ ಅವ್ರದ್ದು. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 4,
Yes.
ಲ್ಯಾಂಡ್ ಬೇರಿಂಗ್ ಖಾತಾ ನಂಬರ್ 6, ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ so and so ನಾನು ಓದಿದ್ದೀಗ. ಈಸ್ಟ್ ವೆಸ್ಟ್ 36 ಅಡಿ, ನಾರ್ತ್ ಸೌತ್ 15 ಅಡಿ. ಈಸ್ ಕಾಂಟ್ರರಿ ಟು ದಿ ಸೇಲ್ ಡೀಡ್ ಇಟ್ ಸೆಲ್ಫ್. ಅವ್ರು ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಇರೋದೇ ಒಂದು, ಇಲ್ಲಿ ಕೇಳಿರೋದೇ ಒಂದು, ಆ ಶೆಡ್ಯೂಲ್ ಬೇರೆ ಆಗುತ್ತೆ. ಅದೇನ್ ಕಟ್ತಾರೆ ಇವ್ರ ಮನೇನ?
In the sale deed, it is mentioned 20 into 12 gajas. That if it is measured in terms of feet, that would come to 60 into 36 millers. What is sought in the declaration is less than what is.
ಮಿಕ್ಕಿದ್ದೇನಾಯ್ತು ಹಂಗಾರೆ?
East to west.
ಇದು ಮೋರ್ ದೆನ್ ಎಕ್ಸ್ಟೆಂಡ್ ವಾಟ್ ದೇ ಪರ್ಚೇಸ್ ಅಂತ ಅವ್ರು ಹೇಳೋದು. ಮಿಕ್ಕಿದ್ದೇನಾಯ್ತು ಅಂತ ಪ್ಲೇಟ್ ಅಲ್ಲಿ ಎಲ್ಲೂ ಹೇಳಲ್ಲ.
Even scheduled also, boundaries also differs.
Differs, my lord.
You take that measurement, it is immaterial, boundary will prevail.
True, my
Even
lord.
that boundaries differs.
True, my lords. Admittedly, they are also claiming for 1/3. I'm also claiming for 1/3. Question of property is situated in,
Both are adjacent owners. Now he is saying that you are constructing encroaching his property. Prima facie, you are claiming on the basis of the sale deed and that boundary in this city is different.
not correct, my lords, because in the sale deed, it is 20 into 12 gajas. But what I have
Now
claimed
you
is,
see that boundary.
correct, my lords, correct, my lords. But insofar as the existing house is concerned, the possession,
Ultimately, Supreme Court said measurement
Boundaries
is
prevail.
immaterial.
Correct.
Boundaries also not telling.
because here I am not claiming what is more than what is available in sale deed, it is less than what is available in sale deed. That insofar as the remaining property, remaining extent, I'll say.
Manjunath.
For the petition.
Yes.
Last occasion, my lords, the learned friend had referred to
Tuesday preliminary stage and ಬರ್ಲಿ.
ಇಷ್ಟೇ ಇದೇನ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಹಂಗೆ ಇರುತ್ತೆ.
B group ಹೋಗ್ಬಿಡು.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಹಂಗೆ ಇರುತ್ತೆ.
B group ಹೋಗ್ಬಿಡು.
ಬರಲ್ಲ ನೋಟಿಸ್ ಆದ್ರೆ ಮಾತ್ರ ಅದು. Yes.
last occasion, my lords, the learned friend had referred to couple of judgments, my lords, which were rendered.
No,
by the
just
learned
give that brief facts, Mr.
Please, I'm sorry.
Yes.
Let's, suit is filed by the respondent, my lords. The petitioner before the honorable court is the VDA, is the defendant in the trial court.
Oh, that land grabbing.
Yes, please.
Section 20.
Yes,
Okay.
yes.
Plus
Now
last,
that
para
Justice
29,
Arvind Kumar
yes.
judgment he has relayed.
Yes, my lord.
the division bench judgment was referred to and was stated, my lords, that the
No,
trial court.
Till that issue has to be decided, it cannot be transferred.
Please. Now, my lords, what the trial court has now said is, if I just request my lords to kindly have the impugned order, page 65, where the reasonings has been mentioned for the rejection of this application.
65.
Please. Para 16, my lords.
Yes.
I have perused the citation relied on by the counsel for the plaintiff with due respect as stated in the facts and circumstances of the case are applicable by the counsel for the plaintiff with due respect as stated in the facts and circumstances of the case are applicable. So here in the application of under the Karnataka Land Grabbing Prohibition Act, so and so. So the relief claim of the defendant to decide this issue is requires trial. At this stage, it cannot be decided and moreover, perusal of section 20, so and so satisfaction is done by the trial court, the civil court. Matter is referred only for the purpose of execution. That is not the purpose of the
Not
suit.
execution.
So one minute, I'll just complete. That court also has to record and decide whether on the questions of title, possession or otherwise. What is required is a prima facie satisfaction. If it is to be considered, my lords, that the entire trial has to be completed. Entire trial is to be completed. Lords, judgment itself will be rendered. That is not the purpose of saying that why there is a special court to be in. It is, if I may permit it is almost akin to considering an application order 39 rule 1 and 2, where the prima facie requirements, whether the contentions raised, whether the pleadings made, make out a case or not. In the, so far as the present court says, it has to give reasons, it has to satisfy itself. But in my humble submission, my lords, the trial court has not endeavored to find out from the pleadings of both the parties to see what the contention of the plaintiff is. Please,
Let them, if required, that evidence can be adduced
on that
decide.
question, on that
Preliminary
question.
My lord, in
only
this
before
regard,
the
my one submission, my lord. My lord, may kindly peruse the page number 58, where the honorable trial court has already framed the additional issue and answered in detail regarding the
No,
objection.
let first decide that additional issue.
That is decided, already decided and passed the order on 30th September 2024.
What is that additional issue?
That is whether the suit is hit by the section 20 of the Karnataka Land
What is
Grabbing Act. That is not available now, my lord. Page number 58 may kindly be pressed, my lord, where my objection is taken on record. Page 58, ink page, may I read, my lord? Additional issue number 1 in the negative,
50?
58, ink page 58. For negative void order dated 30th 9/2024, the said order attained finality.
Now
However,
that there is already an order.
Please read the, let me just read the rest of this one also. What the objection taken is this. Barred by res judicata anta admele. This IA in question may be cannot. My
That
lords,
is
may
true.
direct the trial court.
That is true. Maybe given so many findings, whether is there any order on that issues?
Yes.
What is that on 30th 9/2024?
that
Nobody knows.
very
Both
same.
of them is
We will
not
place
producing.
We'll place the truck on record.
If not
Place
producing,
We'll place the truck on record.
if that
I'll
is
place it
already
on.
decided, you
I'll
challenge
place
that.
it on record. Place it on record.
At the request of parties, leave this matter next week.
Please.
Serial number 7, Shivashankar K.
You for the petition.
It's the compromise accepted by the Lok Adalat that has been challenged. It's the petitioners are the plaintiffs before the trial court. It's they filed the suit for the recovery of possession. Subsequently, the defendant has appeared and filed a written statement, and then the parties have entered into the compromise. Then the compromise petition has been filed and the compromise has been referred to the Lok Adalat. The compromise has been suit for recovery of possession in respect of 4 acres 19 guntas of land.
Yes.
Compromise petition has been filed by the respective parties. The plaintiffs, the petitioners herein, they have agreed to receive 1 crore 25 lakhs, subject to some conditions. The checks have been issued, still we have the original checks, still
So
checks.
where is that compromise?
Compromise page 33 minutes.
33.
Page 32, 33, next 34 only terms and conditions of the compromise.
34 compromise petition.
Yes, minutes. Next page only, that's the paragraph 4. Defendant has agreed to pay the plaintiffs a sum of property within a stipulated period of 1 month from the date of execution of this compromise petition. Subject to execution of this confirmation. Subject to execution of this confirmation deed, within 1 month. Condition has been mentioned, the checks have been issued. 3 checks and the remaining 60 lakhs is concerned by way of cash. There is the terms and conditions have been mentioned. Then he has not come forward, defendant has not come forward to get the confirmation deed within 1 month. Confirmation deed I have produced. Kindly see page 49. Checks also, annexure C, checks issued by this the defendant, respondent. Confirmation deed next page. More than 2.5 years, after 2.5 years from the date of the compromise petition. The 15/12/2008, the date of the compromise petition. The 15/12/2018, 2018, he get the compromise, confirmation deed. He has assured to honor the checks. Then we have requested in the year 2019, then the COVID had started, he has pleaded his financial difficulties. Then 2023 also we have requested. Still the checks have not been honored. Still checks, all the original checks with the petitioner. Still is taking time to pay the entire compensation, the amount agreed in the compromise petition. Only a request notice has been issued.
No, you go and execute. How you can challenge that?
Compromise petition cannot be, the Lok Adalat, the compromise has been accepted in the Lok Adalat. So Lok Adalat, no, we cannot file the application before the same court. That has to be challenged by the petition.
No. See, only order passed in that Lok Adalat challenge 227 if fraud is played.
Yes.
Other than that, no. Here, he has not complied. Go and execute that order. Execution.
He has played a fraud on this petitioner, issuing the check, get the confirmation deed. Not paid the money. This compromise has been recorded before the Lok Adalat.
Fraud by obtaining that compromise. Here, after compromise, the check is given, it is not bounced and all. You take it in a recourse available under law. You can't challenge it. You are, see, by playing a fraud, impersonation, or without your signature, if compromise is done.
The documents,
See,
then he has
no,
not.
this is all after that compromise.
But terms and conditions has been mentioned
No,
and
if
the checks have been
terms and
issued,
condition
that
is
it amounts
violated-
to a fraud. That is the judgment. I will place that judgment.
Yes, yes, when do you want? Next week, after vacation. Yes,
Tuesday,
leave this
we'll
matter
take
after
chance
vacation.
minutes.
You take after vacation, yes.
Till number 8, LM Chidanandaya for petitioner, R Ravi Shankar.
Applying for the respondents in the matter, my lords.
Right, your lordships, there is a connected writ petition, 6233 of 2025, the respondents have filed a caveat. So your lordship will direct to be tagged along with that. In that case, your lordship granted interim order,
Yes.
staying further proceedings.
Leave this matter along with that. You are taking notice
WP
to.
6233.
I am there on record on both. Today I am filing a statement of objections by end of day. I'll furnish a copy by today evening and I'll file it before the
No,
counter.
you are appearing for whom?
Respondents in the matter, my lords.
Both.
Please, my lords.
So and so is undertaken to appear for respondent number 1 and 2. Office is directed to show his name. Call this matter along with that.
WP 6233 of 2025.
Yes.
My lords, a humble submission, a date may kindly be fixed. Both the matters can be disposed of in a single date. Post vacations, any date, my lords.
On 5th June.
Please, my lords.
June.
Please, my lords.
Yes.
Cell number 9, Tumbigi Prabhu Gowda.
Yes, Mr.
The suit is for partition, Lord. The petitioners are the plaintiff before the trial court, Lord. Suit is decreed in the year 2017, Lord. Subsequently, they have filed the Lord of the FDP proceedings. Lord of the still date 2025, Lord of the process is not, Lord of the, even though commissioner report has been, Lord of the, given to the court,
You are the plaintiff or a defendant?
I am the plaintiff, my lords.
You are a, no, anybody. IA is filed application objector under section, hereby application is dismissed.
ಎಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಅದ್ರ ಮೇಲ್ಗಡೆ ಏನಾರು ರಿಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ ಸ್ಟೇ ಏನಾರು ತಗೊಂಡಿದ್ದಾರಾ?
ತಗೊಂಡಿದ್ದು ಆಮೇಲೆ ಮತ್ತೆ ಎಲ್ಲ ಮುಗಿದೋಗಿದೆ. ಈಗ ಬರೀ sympathetic adjournment has been given since from.
Where is that latest order sheet?
Lord, latest order sheet I have produced. That is annexure C, my lord.
IA filed by the applicant herein allowed with an applicant permitted to come on record as a legal representative. Abatement.
Suit for partition.
Raised time to submit an argument for hearing of the respondent. Finally by. ಏನದು who is respondent number 21?
ಅದೇ ಸ್ವಾಮಿ ಅವರೆಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅವರು ಲೀಗಲ್ ಇಯರ್ಸ್ ಬಂದಿದ್ದಾರೆ, ಎಲ್ಲ ಆಗಿದೆ. ಓನ್ಲಿ not of the except the commissioner report and not of the proceed with the.
No, where is that latest order sheet?
Not that is could be seen from page number not 42
for orders.
42 orders.
Respondent number 3 to 5 MOS submitted no objection to commissioner report for order by 2022.
A commissioner reporting objection. Page number 36 ಅಲ್ಲಿ.
1512 2 ಏನಾಯ್ತು?
Lord, the kindly take my lord page number 71, my lord. Last 71 page number.
71.
71 ಅಲ್ಲಿ advocate for the petitioner submitted no objection.
Suit is decreed by judgment and degree dated 28th June 2017. Thereafter, he has filed an FDP proceedings in FDP number 24 of 2017. Till today, learned counsel for the petitioner submitted that
sympathetic adjournment causing inconvenience to the lord of the plaintiff who is
submitted that, except that respondent number 3 to 5, all the parties has no objection for the commissioner report. On 31/7/2024, as time has been granted to respondent number 3 to 5 to file an objection to that commissioner report. As on today, they have not filed any objection. One or the other reason, the matter is urgent. No order has been passed. Hence, he sought for early disposal of that FDP proceedings. In view of the above, without expressing any opinion on the merit of the case, the senior civil judge CJM Chikmagalur is directed to dispose of that FDP 24 of 2017 as expeditiously as possible, not later 17, as expeditiously as possible, not later than 6 months from date of receipt of copy of this order. Yes.
Serial number 10, Udita Ramesh.
Adರಲ್ಲಿ, in view of the prior sought, notice to the respondent is dismissed.
Serial number 10, Udita Ramesh.
Yes. None appear, please this matter after summer vacation 2025.
Serial number 11, Radhanandan BS.
May kindly appreciate, the suit was filed by the respondent Bhanumati. Relinquishment date on 28/6/2013. This fact was made known in the written statement filed by even the family member as well as the purchaser of the property.
Yes.
Now, after filing the written statement, she prefers an amendment application in the year 2023 by claiming that the release deed is to be declared as not binding to the share of the plaintiff. She is a signatory to the document.
Yes.
But she claims a amendment claiming that my lord would get the application at page number 32. The plaintiff for the 32 annexure D.
Yes.
She wants to insert the para 8A. The plaintiff further submit that after filing the case, The defendant number 3 filed written statement and stated that plaintiff executed the alleged release deed. It is improper and incorrect. The said alleged release deed is not in respect of the suit scheduled property and is not binding to the share of the plaintiff in the above case. To declare that this release deed dated so and so is not binding to the share of the plaintiff in respect to the suit scheduled property. Now, with respect to there are various properties to the suit. If she claims the share in all the properties. Now, what she has done is, she claims that this particular release deed, which is already executed by her, requires to be declared as not binding on her. Now, if any relief is to be sought for with respect to a document which is already executed by her, she cannot do it after 10 years is my submission. Because the Article 59 provides.
All that will be available for you seeking for an.
Now, my lord may kindly appreciate 54, my lord. 54, my lord. It's a very cryptic order without referring to the contentions and the judgments cited.
Yes.
It's a very short order. Judgments cited.
Yes.
It's a very short order.
Yes.
Orders on IA number 3.
Yes.
Counsel for plaintiff has filed IA number 3, Order 6, Rule 17, after para so and so. In support of the application, the plaintiff has filed affidavit stating the proposed amendment will not change the nature of the character of the suit. No prejudice will be caused. The defendant number 3 filed detailed objections stating that all the properties are not included in the suit. It's a collusive suit by the plaintiff along with other defendants to defeat the rights. Hence, prayed for appeal. None prayer, none what is my case, nothing is referred to. Limitation not even considered. While then the final order, my lord, the order is next page. The proposed amendment is regarding release deed dated so and so, stating that it is not in the scheduled property. The said amendment will not in any way affect the interest or right of the defendant. As such, IA number Order 6, Rule 17 is allowed. Now, at least the learned judge should have said, question of limitation is open, and it relates back to the date of presentation of the suit. It does not relate to the presentation of the suit. It shall be treated as the date of
amendment which is allowed. It will be related back to the day of that application.
Ashtu nanage clarity kotta saku swami. It can be disposed.
Amendment.
And in fact, if the question of amendment is attacked on the ground of limitation, is what in LIC case the Honorable Supreme Court, my lord would have come across this judgment several times, but still, for my, I only read last para 70, my lord. Factor for consideration. In fact, it was one of the main objections. Factor for consideration. In fact, it was one of the main objections.
No,
next amendment changes the nature of the suit.
That Supreme Court said. See, if that is the issue, it has to be decided.
Roman 4 only, by amendment, the other side loses a valid defense. That's what I brought to the notice of the court, that I would lose my valid defense.
Even after filing of the written statement, 3 years were taken file of application, thereby an acute right in favor of the respondent would be defeated by permitting. The court therefore was right in refused to grant the color. So the refused to grant the color. So the range fairly applies to the fact situation of the parties. Yes, we'll clarify that. Any amendment will be affected from the date of filing an application.
Modify.
Even if there is any this thing, you can raise that as an objection.
Yes. In the meantime, my lord is disposing it.
No, that is
notice
may issue notice.
In the meantime,
any
the matter is on 9/6.
9/6. Before that, you serve a copy.
Till then, till next date, if a date may be fixed.
We'll fix the date before 9 and serve a copy. We'll have it on 4th June. That day we'll dispose of that.
Yes.
That is the only point. Tomorrow it will not be an option for him to file an application without hearing there is a modification.
Yes.
Or
otherwise, if notice is issued, a time bound stay ಕೊಟ್ಟರು ಸಾಕು.
ಅಲ್ಲಿವರೆಗೆ ಏನು ಸೂಟೆ ನಡೆಯಲ್ಲ ನಿಮ್ಗೆ. Yes. In addition, petitioner is also permitted to serve a copy on the counsel appearing for the respondent before trial court. Reach this matter on 4th June.
Yes.
Serial number
the
2.
owner of the property on records.
Yes.
My lord, she is the mother of the petitioner and the
Yes.
respondent number 2 and 3.
Yes.
My lord, she had executed a will on 7/12/2013 in
Yes.
favor of the son of respondent number 2.
Yes.
Thereafter, she revoked that will on
Yes.
22/1/2015.
Yes.
And on the very next day, once again, she executed a gift deed in favor of the same son of respondent number 2.
Yes.
Then she cancelled that gift deed also on 9/4/2015.
Hmm.
Thereafter, the respondent number 2 wanted to have this property exclusively to her. So she was not ready to believe her son also. So she got the cancelled the gift deed and she got the gift deed executed in her favor on 23/9/2015. Thereafter, she filed OS number 25,146 of 2016 against me to evict me from the suit property. That came to be decreed on 11/7/2019. Against that, my lord, I had filed RFA number 1877 going on. Respondent number 2 is not at all cooperating. Here she presses the matter, and meanwhile, after dismissal of the suit, after decree of the suit, the plaintiff filed a suit for partition and separate possession, stating that though the property was purchased in the name of the mother, it was purchased by the income of his father. On that basis, he filed the suit for partition and separate possession. In that, my lord, he had not stated about the will executed on 7/12/2013 and cancellation of the same on 22/1/2015. Therefore, he had filed an application for amendment, which was also allowed, and he has filed the amended plaint also, which is Annexure A. Thereafter, your lordships may kindly see, while dismissing the regular first appeal, while dismissing the suit, while allowing RFA, this honorable court has held about many transactions taking place by defendant number 1 at the instigation of defendant. It has been clearly stated about the existence of these documents. Kindly take, my lord, page number 24 of the
No,
writ
your
petition.
application for production of the document has been rejected.
Are rejected.
Yes.
Points are relevant, one thing. Second is they are in possession of the defendant number 1 and 2.
Yes.
The objection filed by the respondent, your lordships may kindly see, which is at Annexure G, who has not even denied that, my lord, those documents are not in his possession. He has simply stated that defendant number 1 has got power and every document is in accordance with law, everything he has stated. Kindly take, my lord, his objection statement, page 61.
Yes.
Page 61, para 5. The contention about the will.
No, yes, anyhow, you take notice.
I have already filed wakalat to that effect, your lordships.
Yes, madam. Let the notice goes to other respondent.
R1 and 2, I have filed wakalat.
Yes.
It is R3, the one who is aware, notice has not been issued to that respondent.
Yes. Or issue notice. You are appearing
My
for the
lord,
caveat of.
the case
No, your
is on 2nd May, my lord.
This is a 2020 suit. Till this day, your lordship, is a 2020 suit. Till this day, your lordship, they have not bothered to go on with the case.
Yes, yes, yes. How you are taking notice to
1 and 2, please, your lordship.
directed to take notice for respondent number, undertake to appear for 1 and 2. Emergent notice to respondent number 3. Stay of further proceedings in OS number 1181 of 2020, pending on the file of 5th Additional City Civil and Session Judge Bangalore till next date of hearing. Read this matter on 9th June. In the
Grateful,
meantime,
Your
you serve that, yes.
Please, Your Lord.
Serial number 13 adjourned. Serial number 14 Prithviraj BN. Serial number 14.
Lord, in probate proceedings, petition was filed under section 276 of the Indian Succession Act for grant of probate in respect of 3 wills executed by one T.H. Ramchandra. The petitioner before your lordships is named as executor in all the 3 wills. The will has been executed to bequeath 3 properties in favor of the last son of T.H. Ramchandra, namely R. Kailash, who is a physically handicapped person. In order to look after that last son, Kailash, he is named as executor of the will. Probate petition is filed. The wife, will recital is there. She had deserted the testator for about 7 years prior to his death. Even he is named as a managing trustee in that.
No,
It's a
but
registered-
not relative.
Not relative. Not relative. So he is named as an executor. During the course of our evidence in the probate petition, we file an application under section order 26 rule 10A for referring the disputed thumb impression of the testator to fingerprint analysis. That came to be rejected for citing the reason that you are not no way concerned with the family of the testator. You have no right to.
No, see, you are the.
Yes, my lord. In the para 5, page 17.
Appointed Venkatesh Muniraj, aging about so and so, executor of the will. Yes.
Para 17.
Kailash welfare and provided so and so. Yes, so anybody is disputing this will?
The wife who had deserted him, now she has come back and disputing the will. She has filed an objection saying that this all 3 wills are concocted and fabricated.
Then why court has refused to send for handwriting experts when it is disputed?
Court says that you are nowhere concerned with their family. Yeah,
that is not that. You are also a beneficiary under that will.
Page 69.
Yes. Will cannot be only a family members.
Page 69, para 8.
Page
69. The order starts from 63, annexure G. Reasoning is given at page 69, para 8.
It is important to note that
here in
the case,
R. Kailash is a beneficiary of 3 wills and he has become owner of the properties.
No right to claim any right.
Petitioner is no way concerned to the property. Belongs to the T.H. Ramchandra. Therefore, he has no right to claim any.
What is the right of that executor?
Executor ge probate kodbeku. It is the responsibility of the executor to implement the will. Section 222 of Indian Succession Act. Only probate can be given only to the named executor, whether by express or for the will.
Yes.
But so the role of executor is not at all understood by the trial court.
Issue notice. Stay off for
which is in my possession. B schedule. A schedule, my lord, I have purchased and I put up license and they wanted to interfere with A and B schedule property.
Yes.
But then I filed, my lord, this suit seeking injunction not to put up any, not to construct any park or some such thing. Then, my lord, in the written statement, they have not said, my lord, how they are doing it, what is the basis for them to claim this land and all that. Kindly see at page 52, my lord, of the written statement. While denying, my lord, my plaint governments, they simply say,
yes,
para 9, the true facts of the case are as under. The defendant submit that the corporation works as per rules and regulations of the Karnataka Municipal Corporation Act. The defendant further submit that the plaintiff not
saying
obtained.
that without obtaining the.
No, I have obtained license, my lord, for construction in A schedule property. My lord, B schedule property, there is a shed put up by me. And my lord, I have raised trees and plants and structures, my lord. And there we have fenced